What's up, y'all? It's the one and only Lowell Bellinger here to provide an update on some very important housing news. For this October 22nd. A new federal rule will make it very difficult to challenge discriminatory practices in the housing industry. So, civil rights groups, including the National Fair Housing Alliance, filed numerous lawsuits Thursday against the Department of Housing and Urban Development for weakening an Obama era rule that prevented lenders, landlords, and insurancers from discriminating. The disparate impact standard would definitely reduce systematic inequality, civil rights attorneys argue, by forcing lenders to originate loans based on objective criteria that does not discriminate. So, fair housing advocates insist that these provisions to the disparate impact standard would allow for covert discrimination by financial institutions, insurance companies, and housing providers. So this new rule, set to take place effect Monday, would create a substantially higher threshold for victims to file their disparagement claims. So, for example, victims would have to file a federal court claim in order to have their investigations heard. So, just lot more covers and power for these entities to do their discriminatory practices with these provisions, which is why it's causing so much controversy, which is why a lot of people are being upset to have all of the hard work be kind of dishindered. So, very important thing to consider in regards to presidential candidates and their flaws and their benefits. So, Trump administration is going to revise an Obama era rule for fair housing called the Disparate Impact Rule, and they're basically going to make provisions that's going to allow for more discrimination, more cover, and more power for these entities to do what they have to do. So, just a quick little update from Lowell Bellinger. Stay tuned because a lot more will be coming.